So let's talk a little bit about a trust. And I'm talking about a living trust, or what's called an inter vivos trust. This is also a very flexible and very powerful document, and I'm a big fan of trusts. I think most people have heard the phrase avoid probate, and most people want to avoid probate. These days, the tax laws have been changed to where you don't get any tax advantage by putting your assets in a trust or having them go into a trust upon your passing, but you get a whole lot of convenience, and you do not have to go through the difficulty of probating or administering an estate. So, a living trust is also a very powerful document. It allows the trustee broad discretion to manage assets. Okay? Now, you can be the trustee of your own trust. In fact, if you have an inter vivos or living trust now, you probably are the trustee of your own trust, and that's a good idea. You can do it until you're either not able to serve, and you provide for a successor trustee, so that if you're not able, that person simply steps up and takes care of it. Or you can resign, and that person will take over. Any trustee can resign. You can also appoint joint trustees. So for example, if you wanted to have two people on the trust, you can provide that either can act independently, or you can provide that both have to sign. You can change your trust or terminate it at any time. A trust is a private document. It's not admitted in court unless somebody challenges it. And one of the good things in Florida under the Florida Trust Code is the statute of limitations is 6 months to challenge a trust once the trust is given to the individual. So, if you have a living trust, or you are the trustee of a living trust for someone, and that person passes away, by all means, copy the trust and give it to the beneficiaries. They have 6 months to go to court and challenge it. Or, as they say in another context, forever hold their peace. And that's a good thing. Probate can last a very long time. Okay. The trust continues after your death. Remember, I said that a power of attorney is of no effect upon your death. A trust continues, and that makes it a very good device for avoiding probate. A trust can continue for years if necessary to provide for spouses or disabled persons or children. Now, I do want to say that a trust is the most highly taxed item, so you don't want to be dealing with an irrevocable trust that lasts for a very long time if you don't have to, because the taxes are pretty high on that. If your trust is mainly designed to dispose of your assets instead of a will, you don't have to worry about that. It's when you're wanting to put things in trust and provide for years and years and years for people, you want to think about whether that's the best kind of device tax-wise. The trustee can have discretion to distribute assets in different amounts or different forms according to the needs of the beneficiaries. So for example, in a trust, you can provide that 4 children will share equally in the assets of the trust, and then the trustee can have the discretion to give the car outright to one and count the value of that car as part of that person's share, to give cash to another, to allow another to live in the house, etc., etc. You don't have to do it by selling everything and distributing cash. And your trustee can have discretion to handle that. You can name any beneficiaries you want, or you can define descendants to include people other than blood relatives. The traditional definition of descendant or heir under Florida law is blood relatives, and it goes in a particular type of order, starting with spouses and then to children, and if no children, up to parents, and then out and down, right? But you can define it any way you want to. I've frequently done trusts for people who raised stepchildren. And they raised them since they were small children, and so those are their children to them. But legally, if that person were to pass away without a will or without a trust, the stepchildren would get nothing. So in order to provide for that, you can provide in your will, you can also provide in a living trust that these people are your descendants. You can even provide that their children are part of your descendants. So it gives you a lot of flexibility to plan exactly as you want to. Importantly, in a living trust, while you're here, the trust is solely for your benefit. Now, you can make it different, but generally, for this particular purpose, we make it so that you are the first trustee, you are the beneficiary of the trust, it's solely for you, do what you want with your assets. Even if you're not the trustee, if you're the first beneficiary and it's your trust, you get to tell the trustee what to do. In a lot of litigation cases, when people had a big settlement, I'd recommend that they do a living trust. And then, they didn't have to. Now, these were people who were pretty seriously injured. So, physical mobility was difficult for them. They may have traumatic brain injuries. So they could just call the trustee and say, I want you to do this, I want you to do that, etc. You can do that with your trust. Okay. But, very, very importantly, even though a trust is flexible and powerful, a trust only applies to the assets that are placed in the trust. So it only applies if the trust is listed either on the title to the asset, and if you went to the property appraiser's website and you looked at who has the deeds to the properties here, I bet you will see some that are in trusts. Okay? So you can either list whatever the asset is, you can do a bank account in the name of the trust, you can do certificates of deposit, stock, accounts. I wouldn't put my car, you could, I'm not sure it's a great idea. You can put your property in the trust, but if it's titled in the trust, it's part of the trust. Or you can list the trust as a beneficiary, which is the really useful thing. Then you only have to remember the words you use to list your trust as the beneficiary on everything. And then, when you pass away, everything just goes directly to your trust and is handled according to the trust. And as I already said, it's rarely appropriate to title everything in the name of a trust. So, you probably need a power of attorney to manage some assets for you, and at least to be able to change your assets if need be. And then a will is also needed in order to catch the things that didn't get either titled in the name of the trust or where the trust was named as beneficiary. See, I can't imagine a lawyer that doesn't also do a will. Usually it's a pour-over will where everything just goes through the will, through the estate, and into the trust. Okay. For long-term care planning, as we said at the introduction a little bit, and I'm not going to talk a lot about long-term care planning here this morning, except to stress flexibility. Because as I've said many times, and as you already know, life is unpredictable. So what you want to plan for in your life plan is the flexibility to change things if you need to. So you want to be able to plan so that somebody, if you needed to be eligible, for example, for Medicaid, $76,680 a year. Many people's estates would be rapidly depleted paying $76,680 a year. There are ways to rearrange assets so that a person qualifies for Medicaid assistance in a nursing home. There are provisions in Florida law for what they call the Medicaid diversion program, where Medicaid will pay for some services in the home. And then there are some all-inclusive services like the PACE program, where you can get outside services. Those are limited and there's usually waiting lists, etc., but one would hope that as time goes on they'll become more and more available, because it is in the best interest of the taxpayers and the state to keep people out of nursing homes. But right now they're somewhat limited. I wouldn't give up on them, but nonetheless don't count on them. But the important thing to know is that the Medicaid criteria are very, very low. So you want to move assets completely legally. Everything has to be disclosed to the Department of Children and Family Services. They have to approve everything, but there are ways to move assets around so that you qualify for Medicaid and your spouse continues to be able to live in the community, and there are assets available to cover the things that Medicaid won't cover. And I'm sure that some of the other speakers will talk more about that. Even in a nursing home or an assisted living facility, you might want to bring in some outside services. So you need the flexibility in your life planning documents to have that happen if it needs to. Okay. Now, I don't know, I don't know why I put this at the end. Maybe I should have put it at the beginning. We don't always want to talk about end-of-life care, but we really do need to. And we don't want to think about end-of-life care, but we really need to. I'll give you an example from my own family. My mother had emphysema. And as time went on, she first started with an oxygen concentrator, and then she required oxygen, and then she was tied to her oxygen and her pulse oximeter. My mom spent a lot of time on the computer on the COPD, that's Chronic Obstructive Pulmonary Disease Forum, with other people who had this disease, and she was terrified of a ventilator. Terrified. It actually isn't easy to tell you this, because I'm a lawyer, right? So there came a time when my mother became unresponsive, and my father called 911, and they took her to the hospital. And when she got to the emergency room, they put her on a ventilator. And we didn't know if she was going to make it. She was in ICU for days on a ventilator. We didn't know what was going to happen. We didn't know if she could come off the ventilator. So when I got there, and when she got enough oxygen that she was lucid, she couldn't talk because she had a tube down her throat, but she could write, and she was not happy. And she wasn't happy with me, because I had not put this in place for her so that didn't happen. Now, it probably would have happened anyway because she wasn't terminal. However, she was very upset with me, and I got to stand in ICU and have a conversation with my mother about removing the ventilator. Now, it was my pleasure to do that, to ask her. And what I said to her was, Mom, I really believe that you can wean off this ventilator. I think you're going to be okay. But if you can't wean off the ventilator, do you want us to remove it anyway? And she said yes. Now, the good news is my mom weaned off the ventilator, and she lived several more years, a full and healthy life. That told me a number of things. First of all, it told me that I don't know everything, and neither did she. Because we didn't know. Being on a ventilator, even though you have COPD, doesn't mean you'll never come off. So, and I also learned we need these documents in place